This is ridiculous. No, it is simply what your argument is ridiculous. We can go round and round in circles. Motion denied. Motion denied. I'm not going around and round in circles on this. Court does call the case Ryan Palmer versus Sonia Stoneberg. Huh?
You just went with that.
All right. Where are we on this case?
See her.
She hasn't been here. Okay. Like take a default. All right. It's going to be, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so we got. All right. It's a claim.
For determination tendency based on the damage that lease violations, the damage she's caused to property. She denied it, but I'm happy to show you a picture of the damage. Just
all right, but she has damaged the premises.
Yes.
All right.
The holes literally shouldn't go out. And we've had major tendency for violations of lease cost clients time and money. Parenthetically, she hasn't paid rent since January. And I did set her notice, a 7-day notice, not paying money.
All right.
So I'd ask for a judgment for possession, and I'd ask that escrow be released. But
all right. Judgment.
You didn't pay her a full escrow.
She did not. She only $550. Judgment to the plaintiff, that is by default for possession. There is no redemption amount. The writ to issue 10 days. Escrow released to the plaintiff. He can have those, man. All right. Thank you. Evergreen Apartments versus Matthew Chavez.
Morning, Honor. James, thank you for the plan.
Good morning.
Good morning, Matthew Chavez.
All right. And where are we on this case, folks?
Yes. ESA paperwork in. You got it approved. The ledger's been adjusted to reduce pet rent from the date he turned it in. The current balance, including costs, is $1873.61. I don't think there's a tribal issue, but that's up to you, sir. 1873.61.
Sir, your position.
Yeah, I don't see where they took the pet rent off.
Yeah, great. It's minus 17 months of pet rent. It's prorated from the date. It's $30 a month from the date you turn your paperwork in. $30 a month. You turn your paperwork in, so they took off 17. And you won't get charged going forward.
Okay, well, I have to, well, my Evelyn housing worker, she said she needed a total for what I owe, so she can try to get
1873.61 is what you know.
That's what I'm
Okay, all right. So
she's she's not here, I guess. She said that she needed a total so she could try to get some different organizations to
try to help you out. Okay, so let's do this. If I were to issue it, today's 22nd, right?
Yes.
Sorry, we're going to be on the 2nd. Here's what I'll do. I'm going to find no tribal issue after hearing in this case. I'm going to issue a judgment for that amount. Okay. At the same time, give your worker time and you to work it out. No writ until the 9th of May.
This is an important moment because Judge Simpson separates two legal questions that many viewers often combine. The court has already determined that the landlord is entitled to a money judgment based on the ledger presented, but that does not automatically mean immediate removal from the property. Instead of rushing enforcement, the judge intentionally creates a short window for outside rental assistance to work. That tells us he is balancing the landlord's legal right to collect rent against the practical possibility of avoiding an eviction altogether. Notice how the defendant doesn't deny owing money. His concern is whether the accounting properly reflects the removal of pet-related charges after his paperwork was approved. That's a credibility distinction worth paying attention to. He's disputing the calculation, not the existence of the debt itself. Did you notice the judge never allows the hearing to drift into speculation? Once he concludes there is no genuine factual dispute requiring trial, the focus immediately shifts toward giving both sides an opportunity to resolve payment before enforcement becomes necessary. That kind of judicial case management is designed to reduce unnecessary litigation while still protecting the plaintiff's judgment.
All right. All right, that extends your time a little bit, about a week or so out.
Must have been a judgment, Your Honor.
All right. And you were able to get, the Humane Society took care of you, right?
Very next day. Thank you very much.
You're welcome.
Thank you, sir.
Thank you. Jerome versus Cassidy. Counsel, want to state your appearances, please.
Your Honor, Agnes Cooper, appearing on behalf of Alec and Jerome. Morning, Your Honor. Francie Nova, appearing on behalf of Barry Cassidy. On behalf of Eviction and Holdings. And Gail Rose. Gail Rose on behalf of Paul Cassidy.
All right. Okay. And where are we? I'm almost afraid to ask, but.
Your Honor, we've attended mediation. We have continued discussions since that time, but as of right now, we're unable to resolve the matter on our own.
What's that mean?
I think it means we need a trial date, Your Honor. We need a scheduling order so that we have time to file an answer and a counterclaim because we haven't done that with the fourth claim, the fourth case.
I know what,
Okay.
but that's because you guys told me you'd be settled.
So
I didn't.
We need today, Judge. Then we're going to file a motion to remove it to the circuit court after we get our answer and counterclaim.
Why don't we do this? I'm going to pass the matter, and then I'm going to meet with counsel and back, figure out exactly where this thing is and what we're doing on this. Okay?
Thank you, Your Honor.
Thank you. Estate Solutions versus Daryl Daniels.
Good morning, Your Honor.
Good morning, sir.
For the record, Neil Chan is appearing on behalf of plaintiff.
Good morning, Mr. Daniels. How are you?
Good.
Okay. Where are we?
Your Honor, we've agreed to the terms of a consent order for conditional dismissal. It indicates under further conditions, paragraph 3, that the defendant shall vacate the premises on or before May 23rd, 2025. Plaintiff shall reimburse the defendant for the rent paid in the month of February in the amount of $500. Return the security deposit in the amount of $650 and pay for moving expenses not to exceed $500 upon vacating premises. Paragraph 4B has been checked. I will explain the court rule 4.201J to Mr. Daniels, and then he has 3 business days to ask for the hearing date. If you believe you should not have entered into this, Mr. Daniels did sign the consent order.
Sir, is all of that correct?
Yes, sir.
Regarding that conditional order dismissal, do you have any questions whatsoever regarding that? No? All right. You have no problem with me signing it? All right, great. Have signed it. Thank you guys for working it out.
Thank you, Your Honor. Have a good
Thank
day.
Take care. Town Center Place versus Jacqueline King. She can have a seat there. All right. This is your motion.
Your Honor, we request, per COD, that Ms. King be granted an additional 30 days to move. As per the terms of the COD, her condition was to show that she had, been looking for new house. I provided a letter from Ms. Little from Housing Europe for Seniors showing the, properties that she's applied to. Since that letter, she's even applied to even more. She's been accepted at about 3 of them, but she hasn't had her interview yet. And then even after she has her interview, there's no guarantee that the apartment will be ready in a certain time. And I also filed a
So when are her interviews?
would you mind if little thumbs up?
Yeah. That's fine.
Take the name correct.
Okay.
So yeah, so Ms. King has been selected for 3 apartments. And one specifically, she's in the process of an interview. We don't have a date yet because there's still some pending paperwork. It's a really long process to get all of this done in such a short time frame, honestly, to get everything done. And so I would think the interview would be next week or so. She just needs to get down there and get it scheduled. I mean, the apartment that, have the biggest lead on isn't one we really want her to go to, because obviously in this short time frame, she's not gonna get a great option to move into. So it'd be nice if we got her from the others, but we'll probably have to.
Okay. All right. Thank you. Response.
We're asking, for a written for the additional order of dismissal to be enforced. Part of the additional dismissal order was that she paid rent, she paid full rent, she paid time rent. And we've informed her, as you see in the answer, of she recertified, her rental increase went up to $270 a month, and she's still been paying $247. So she owes currently $79. And she was supposed to pay on time, full amount of rent stated in the conditional dismissal. She has not. She's been informed that she had been paid by a letter paying less both times, and she has not submitted any extra money.
Okay.
Yeah.
Your Honor, the ledger that plaintiff added, submitted with their answer is not the ledger that they seem to have removed all of the hat payments and Ms. King's credit, and produced this ledger that they claim is what she has paid. However, I've asked on more than one occasion for a complete ledger. This ledger starts in April of 2020. Ms. King has lived at Town Center for at least 8 years, and she's been in this new apartment for.
When was she recertified?
She was recertified.
I think it's in April or March.
It was January 16th, 2025.
January of this year.
Yes. The effective date was March 1st, 2025.
Of the rent. So it's March and April. That.
And go ahead. Your Honor, as part of the terms of the consent order for conditional dismissal, we were to wipe her ledger as
I recall.
So before that date, it shouldn't be in controversy here.
Well, that's what I was curious about.
Your Honor, the reason it's in controversy is because they wiped her account and included her February's payment, supposed to be February 7th, and they wiped her credit. Now, what my understanding of wiping her account was to remove the charges that she had since.
She was to zero out, that's what was supposed to happen.
Okay. So she gets zeroed out the credit that she has and the payment that she made for February? Because if you look back to prior to them filing this case, she had been paying $200.
I'm not relitigating the case.
Okay. Well, Your Honor, the COD says that she abide by the terms of the lease. This is subsidized housing. Paying rent late, which she didn't do because she paid on the 5th, and they didn't process it until the 6th. And not paying the full amount of rent is not a eviction cause. for subsidized housing. They are, required to offer payment arrangements. The goal is for subsidized housing.
She entered into a COD that she was gonna pay her rent timely.
No, COD says she would not violate her lease. This is not a non-payment of rent case. Never has been.
Does she have the 79?
Yes, Your Honor, she has $79.
Then why are we arguing? Why doesn't she pay it?
Because she has credit on her account, Your Honor. It's not fair for them to keep the credit, and they reverse the half payment at a different.
All right.
time. And
This
it's not a
is
violation- it's not a violation
This is
of the lease.
ridiculous.
Exactly.
No, it is simply what your argument is ridiculous. Because what I'm gonna do is she was to abide by the terms. She has to pay her rent on time, got her account zeroed out, gave time for her to find new housing, gave an opportunity to then come before the court and ask for additional time if she showed that she was doing that and complying with the COD. She's not in compliance with the COD. I'm gonna deny the motion to extend the time.
Your Honor, thank you.
This exchange illustrates why precise wording inside a consent order matters far more than later arguments about intent. Defense counsel attempts to reframe the dispute by focusing on accounting credits, subsidized housing regulations, and whether late payment alone is an eviction ground. But Judge Simpson is looking at something much narrower, the conditions both parties previously agreed to in court. From the judge's perspective, this hearing is not a second opportunity to renegotiate the original agreement. It's simply a compliance review. Once he concludes that the agreed conditions were not fully satisfied, the legal analysis becomes straightforward. There's also an important courtroom strategy lesson here. When counsel continues arguing after the judge has already explained his interpretation of the order, the discussion begins moving away from persuasive advocacy and toward repeating previously rejected points. Judges generally have little patience for arguments that don't address the specific legal basis of their ruling. Ask yourself this: if you were reviewing the written agreement alone, would you interpret it the same way Judge Simpson does? That question often determines whether an appeal has any realistic chance of succeeding, because appellate courts usually begin with the language the parties themselves accepted.
Yeah, how is she not in compliance with the COD? It doesn't specifically say that she has to pay her rent one time.
It
or the
does.
full amount.
It does.
It has things for late payments. It has other things that if you go to paragraph 23 or whatever, it lists the things that you can terminate. Do you have?
You sign, I'm sorry. Your Honor,
Yes.
the second line from the last line says defendant will pay March and April rent at normal time. Your signature is right here.
And she paid on the 5th.
She did not pay her full rent, ma'am.
Okay, but she paid on the 5th.
She didn't pay her full rent. We can go round and round in circles. Motion denied. Motion denied. I'm not going around and round in circles on this.
So, Your Honor, we'll submit a writ.
Thank you.
Thank you, Your Honor. You have a good afternoon, Your Honor.
Yeah, too late. Good, thanks. All right, he's back in Zoom, so let me deal with him and then I'll deal with the gang of four. Court recalls the case of S&T Holdings versus Michelle Stacy.
Ready, Your Honor. Tracy Thomas, appearing on behalf of plaintiff.
Hello, your name?
Michelle Stacy, representing South.
All right, and this is your objection to garnishment?
Yes, sir.
Okay, and what's your basis for the objection?
Received any information to defend myself against the garnishment before the garnishment has been issued.
What do you mean by that?
I filed my state tax return, and I received a letter from the state saying that I will not receive my tax return because it has been given in the month to SC Holdings.
Correct.
So there was paperwork saying that I could defend myself to get that tax return.
Where you could say that again. Did you could defend yourself to get the tax return?
Yes.
Well, I'm not-
The same thing as getting garnished on a paycheck. I have a minute to
to say that I still need a paycheck? Is that the same thing as being garnished from my tax returns? That's my understanding.
Well, I guess I'm unclear as to what you specifically wanted, because what I have here, ma'am, is that on June 18th of 2023, there was a money judgment in the amount of $3,381.14. Okay, there was a money judgment. So that would have been your first notice that there was a money judgment against you. Okay. The garnishments are usually sent without notification to the party, particularly tax garnishments. Okay, so I think you may be looking for something that really doesn't exist. Certainly with regard to wage garnishment, theoretically, you get one of those without notice too, but usually the employer or whoever is issuing the check kind of notifies you that something is going on. They may or may not, right? But in this circumstance, your notification to challenge the withholding of your taxes, you may be able to take it up with the state, but certainly as I look at the file and have reviewed everything, there's not anything improper in terms of what the plaintiff in this case has done in terms of garnishing your taxes.
I apologize for the time.
You apologize for?
We're wasting time.
Oh, no, don't apologize for that. That's fine. But as long as you understand what I'm saying, I just want to make sure. Okay.
Please, could you tell me who exactly you're representing? Are you representing someone in Milan to come see Paul?
Say again.
I don't know what SC Holdings is. Now, I owe a lot of people a lot of money. I'm 6 to 8 weeks away from filing bankruptcy. So
I got you. Was it a?
Your Honor,
Go ahead, Mr.
it's her former landlord. S&C Holdings is Park Lane Apartment.
Okay, okay, so that's the Milan apartment complex. Thank you so much.
Okay, got that? Okay. All right. So your objections are denied. Okay. Thank you.
Thank you, Your Honor.
Thank you, sir. It does call the case of Sycamore versus P.
Arizona, 65390, on behalf of plaintiff. I do appreciate you putting this at 11 for me to be able to make it.
Not a pro. Not a
I
pro.
appreciate that as well, Your Honor.
Oh, you were just trying to tag on. No.
Jill Bauer. Jill Bauer on behalf of Ms. P, who is present, I'm from Legal Services, P number 69260. I do want to let the court know Ms. P was assaulted this morning.
Oh, I'm sorry.
A near stranger and is
That's
definitely want to be here.
understood.
She's not feeling the best.
All right. Okay. This is your request.
Your Honor, first of all, I would never want court to think that I essentially misled the court, so I did lose track of the order that Ms. Newman highlighted in her answer. However, I do think that the order is subject to interpretation. And it does say that that my client would remove any and all belongings, and I think the definition of belongings tends to be smaller personal items that can be easily moved. At this point, the other thing is we had a discussion on the record of Ms. P back in January of our request that Ms. P be able to move her items to a part of the house where they wouldn't interfere with the repairs. And it was represented at that time that there was structural damage to the unit. However, I reviewed the fire report. It doesn't say anything about structural damage. And now that a lot of the drywall debris has been cleared from the ceiling, I really don't, I mean, I'm not an expert, but I don't see that there was structural damage to the unit. So where we are at this point is.
I think the import of that, I don't mean to interrupt you, was that in essence, there was going to have to be a gutting of this place. And so the issue of whether or not there's actual damage may have to be assessed at some other point, because my understanding was the unit needed to be gutted, which is why things could not remain there.
I just don't think that that's accurate at this point, that it actually had to be completely gutted. But I just wanted to, where we are at this point, Ms. P went in, she removed what she could into 2 vehicles that were in the parking lot. And then those vehicles were recently towed and she wasn't able to get any of those belongings. So now she's down to.
What do you mean?
She had 2 vehicles that were parked outside of her unit at Sycamore and they towed them. And those vehicles had all of the belongings that she was able to salvage. So she's down to a few items that remain in her unit that she doesn't have the finances or ability to move, and she would like them to remain in the basement. And it's a washer and a dryer, an air conditioner, and 2 barbecue grills. Is what she's asking to store there while the repairs are made.
Council, my problem here is this. As we were working through this case, and why the order reads the way that it is, was to give Ms. P time to get her things out of the unit. And I'll be honest with you, and I don't think you're trying to mislead the court or anything. I mean, people, there's a lot of orders that fly around here, so I'm not thinking that at all. But she's got to get the things out. I mean, that's kind of where we were trying to figure out how that would come about. And I mean, the date and the timing of everything, if you recall, I think we went through that 2 or 3 times to try to get that done. One time where there was sort of a ruling from the bench, but there wasn't an order, and then that didn't happen. And then we had to come back and try to deal with it again. And now I'm here again. Yes.
And I would like the court to know, every time I've been asked from opposing counsel for her, whether it was, if we go back to the date that you ordered, which was, I believe, February 6th, Ms. P didn't show up until 4 o'clock to remove the items, and office closed at 4:30. I received an email 2 weeks later from opposing counsel. We gave her that entire day to do it. She took what she wanted. I just want to address the cars. The cars were inoperable. HUD actually sent my finding, and it's in my brief. It's in my motion, the copy of the email. HUD made Sycamore tag them. They were inoperable. The day they were tagged on Friday, they were not moved until Tuesday. Council knew about it. As soon as they were removed, I got for council a copy of where the towing company and where they were at, so she could go get her stuff. I feel like we bent over backwards to give her time. Then I got a message about the washer and dryer that she didn't want to lose that. I got my client to agree to give her 7 days to do it. Then last Friday, the time frame came and went, and she never came and got it. This is not Sycamore has bent over backwards to give Ms. P the opportunity to get her things. And here we are again, and we're asking for it again. And last week when council reached out to me, I said, get it done by Monday. Because I told my client, hold off. You can see it in the emails from my client. We're holding off. And here we are, we're asking for more time. It's been 4 months, 5 months.
Your Honor, the reality is that Ms. P is in this situation because she's living in poverty. She doesn't have the resources to move or store these items. She tried to get a storage unit. They wouldn't rent her because she doesn't have a debit card. I mean, she has done nothing wrong, and she's basically too poor to take advantage of the opportunity to move and store these items. And I just don't know why they can't remain in the basement while the unit is being repaired. There's no damage to the floor on the first floor. If you look, there's minimal damage to the structure of the ceiling on between the first and second floor. I brought pictures that shows no burning into the wooden structures between the 2 floors. So I don't know why they would be in the way if they remain in the basement while they repair.
The order, the email from HUD is very clear. The cars needed to be removed, the property needs to be trashed out. My client is doing what they're being told to do at this point.
And if we just look at it just on a whole other angle, but I mean, I'm not even there necessarily, but Ms. Bauer, if the property were to remain there and something happened to the property, whose responsibility would it be?
I haven't discussed if my client is willing to waive unintentional, or as long as it's not intentional damage.
Well, but see, that's where that's where the problem comes in. I mean, if somebody, and I'm not even saying that it really by order is reflective of this, but even if the property was there and then we get into and somehow gets damaged, which can happen when people are doing construction. I mean, it can just happen. But then you get into all this litigation and hearings about, was it intentional? Was it this? Was it this? They didn't put it in a safe spot. So really, Sycamore or their contractors, I mean, you get into a whole bunch of other issues, which all can be avoided if the property is not there. We don't have that issue. I'm sure that's one of the reasons HUD is saying you got to get everything out. We're not, looking for Sycamore or HUD or anybody else to, or any contractor we hire to be placed in a situation of trying to be the guarantor of the safety of somebody's property.
Well, Your Honor, she's been homeless for 6 months now, and the repairs really haven't begun. There's been some clean out. I mean, even if they would let her move them into a unoccupied unit or something, she just does not have the resources to store them.
I know, but you're asking the landlord to assume basically to bail this property, which with that comes certain responsibilities for the landlord. I don't know under what possible theory I would ask the landlord to do something. To care for somebody's property. I mean, it's not their business. It's not what they do. And again, just hypothetically, let's say the landlord did put them in some other place on their property, and somebody comes in and creates some vandalism at that place, destroys the property or damages the property. Who's the one responsible? And that's the problem. To answer your first question, in looking at my order, the intent of that order is that she remove from the premises everything that she wants to keep. That at the point at which if she leaves something, then the landlord's in a position to say it's abandoned, the landlord can get rid of it and do what they need to do in terms of repair that unit.
SP, she's just pretty devastated and was hoping to be able to hold on to those last few things. So that's why.
Right. No, I understand. I understand why you're doing it. I get all of that. Problem is, with the cars, The cars are inoperable. You can't just put them there because ultimately they're going to be taken off the premises. That would happen anyway. So, I don't think.
I'm sorry.
Go ahead.
I wasn't assessing any particular, I wasn't like making a judgment about that. I was just letting the court know that it's been like a domino effect, like, okay, I want to keep these belongings. These are, my personal belongings, and I can't get a storage unit, so I'm going to put them in these vehicles. And then they were in the vehicles for a while, and it seemed like that was going to be a solution. And then all of a sudden, she finds out, like, they may have been tagged before, but she didn't find out immediately that they were tagged. And then suddenly the vehicle, she goes to look for the vehicles, and they've been towed. And then she wasn't able to get the belongings out of them. So it's just been a domino effect where she's done nothing wrong. She's just a series of unfortunate events. And now she's lost almost 100% of everything material in her life. So it's just the thought of maybe being able to hold on to those last few items was. Ms. P just wanted the court to know that when she first put her belongings in the vehicles, they were operable, but because she was homeless and they were sitting there, I think one of them, the battery died, and one of them, a tire went flat.
And they become inoperable, which is why then after those, if those are the only two things, they tag them with the thought that whoever has the flat tire or the battery where the vehicle won't move or the like will then come and do what they need to do, either to move the vehicle or to put it back in operate. I mean, so I get that.
I think she just wanted you to know that she didn't intentionally leave.
No, and I'm not saying that. I'm just saying at some point, this part of it has to end. And Ms. Bauer, a lot of folks come before the court with a lot of problems and a lot of issues, and a lot of sort of obstacles to overcome. And I think in trying to get through this, and I have to give Sycamore credit because, they could have just taken a really hard line. They didn't, trying to get this going. I've been patient with what might be scheduling or trying to have her get the stuff out. But, at some point, sadly, we just have to be done.
Thank you, Your Honor.
So I'm going to deny your request for any additional time. What is, having said that, then what is Sycamore's intention in terms of they're not intending at this point to let her back in to get her things set?
I mean, I can make it happen. And that was, I've offered multiple times. So if she wants to go get the washer and the dryer and the air conditioner or the grills, she wants to do it by today, I think she can go. I have no problem with that. I've never had a problem with that. I just need her to actually do it.
She said she would like a chance to get the grills, but she doesn't have any place to put the washer herself. So can you go today by 4 o'clock today to get those grills? I'm assuming if you're offering, then you get that.
If they're there, I don't know what's there, what's not there. Like I'm just, you're telling me that that's what's there, and then she can go.
Well, she saw Sycamore personnel roll the grills to the office.
I asked them more, and I'm putting on our, they told me they did not do that. But if she wants to go today by 4 o'clock to go to get this one. Let's put it on the record. I need to know what time she's going so I can tell them. So let's give me a window.
Okay, so she just wants the court to know she videotaped them moving the grill and she has talked to someone that said that they're back off. So
You want to know what? I'm done. I'm not going to litigate anymore. I mean, at some point, the problem is everybody is, as we've said, bending over backwards to try to do this. I issued just now denying your motion, which means really we're done. I was looking maybe, and I think Ms. Zanin was trying to do the same thing, a bit of compassion to say, okay, if you can get these now, do it, but you got to give us a time. But I'm not going to go through litigating. They took my property. They did this. I'm done. Whatever else anybody else wants to do, you can do it, but you're not doing it with the court sanction. That property at this point, since she has not removed it, is considered abandoned. And that Sycamore may do what they need to do with reference to taking that property out. If you guys work something out without my involvement, do what you got to do. But I'm done.
I do appreciate the court hearing this.
All right. Thank you.
Thank you.
All right.
By the conclusion of this hearing, Judge Simpson's reasoning follows a consistent legal theme that appeared throughout the case. Court orders only work if deadlines have practical meaning. The court acknowledged the tenant's difficult financial circumstances and repeatedly recognized the hardships described during the hearing. However, sympathy alone cannot replace compliance with an existing order when the opposing party has already provided multiple opportunities to perform. Another key point many viewers may overlook is the judge's concern about future liability. Allowing personal property to remain during major repairs could expose the landlord to additional disputes if items were damaged, misplaced, or destroyed during construction. Rather than creating another round of litigation over responsibility, the court chose the cleaner legal solution by requiring the property to be removed. Behaviorally, Judge Simpson remained patient for much of the hearing, allowing extensive argument from both sides. But once it became clear that the discussion was simply repeating issues he had already resolved, his tone became noticeably firmer. That shift signals the hearing has moved from fact-finding to final decision-making. The broader legal lesson is straightforward. Once parties enter a consent order, every condition inside that agreement becomes critically important. Missing even one required obligation can undermine later requests for additional relief, regardless of how sympathetic the surrounding circumstances may be. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.